like a small boat on the ocean, sending big waves into motion, like how a single word can make a heart open. I might only have one match, but I can make an explosion. And all those things I didn't say were wrecking balls inside my brain. I will scream loud tonight. Can you hear my voice this time? This is my fight song. Take back my life song. Prove I'm alright song. My power's turned on. Starting right now. I'll be strong. I'll play my fight song. And I don't really care if nobody else believes, 'cause I've still got a lot of fight left in me. Losing friends and I'm chasing sleep. Everybody's worried about me. In too deep. Say I'm in too deep. And it's been 2 years, I miss my home, but there's a fire burning in my bones. Still believe, yeah, I still believe. And all of those things I didn't say were wrecking balls inside my brain. I will scream loud tonight. Can you hear my voice this time? This is my fight song. Take back my life song. Prove I'm alright song. My power's turned on. Starting right now. I'll be strong. I'll play my fight song. And I don't really care if nobody else believes, 'cause I've still got a lot of fight left in me. A lot of fight left in me. Like a small boat on the ocean, sending big waves into motion, like how a single word can make a heart open. I might only have one match, but I can make an explosion. This is my fight song. Take back my life song. Prove I'm alright song. My power's turned on. Starting right now. I'll be strong. I'll play my fight song. And I don't really care if nobody else believes, 'cause I've still got a lot of fight left in me. No, I've still got a lot of fight left in me.
Hello, hello, hello. Good morning, everybody. How are we? I hope you're all well. So, Aaron Spencer, this is a very interesting case. I was sent this by Josie and by Lady Di, and thanks to Alicia as well. She sent me stuff as well from it. I think Alicia originally sent it to Josie as well. This is, when you start going into this case, it's mad. This case is mad. It's maddening to watch it, to hear about it. There's lots of facets to it, which we'll get into now. But wow, when you hear the story, it's mind-boggling what this guy is going through, what Aaron is going through. You can't put into words what you would do in this situation. I've read it all. I'm all caught up as much as I can be, because there's still stuff we're waiting for. But you know, I think that he deserves a medal. He deserves a statue for what he did, which again we'll go into. Shout out to the Wrongful Pod, the ladies will be covering it. That's always going to be a good show. So Wrongful Pod, he's out on bail, I believe. Alicia could probably verify that. He got bail of $150,000. But yeah, the Wrongful Pod is also going to be covering this. And those beautiful ladies, they are awesome and great, and they put me onto this. with Lady Di. So, whew, where do you start with this case? It's a doozy. First of all, we'll start by saying if you want to donate to the cause, please go to Give Send Go. Why is someone ringing me right now? Mute. It's pinned at the top of the stream. It's pinned in the description box, the link for it and everything. Please, I would encourage you all to, if you can, wherever you can give, please don't give it to me, give it to them. They deserve it. So it's, as I say, it's a doozy. But again, hello everybody. Hello Robin G. Hello Alicia. Hello J Mac. Hello Sarah P. Hello. Sorry, I missed everyone here. Lady Di. Hello, my darling. Who else am I missing? Am I missing anybody? I think probably if I have missed you, I apologize. But hello to you all. Welcome here. So the plan is I'm going to give you a brief overview. There's loads of documents. Well, not loads, but there's a handful of documents. I'm not going to go through them today. Hello, Christine. What I'm going to do is give the basis of what's happened, see what you think about it. I'm also going to stream the hearing. There was a gag order hearing. It's about 50 minutes long. I'll play that as well, more towards the end. So I'll give you a brief overview and play that afterwards. We'll talk about the charges and stuff like that, see what you guys think you would do in the situation. But yeah, it basically involves Aaron Spencer, who killed a predator, and let's make sure that we know that he was a predator. The guy kidnapped his daughter, and he chased him down. The guy attacked him, and he killed him. Well, in addition to that, this predator also sexually abused and groomed that said daughter. I think she was 13. So, yeah, it's a doozy. We'll go into it. I will go into the broad overview of the case, the charges, 43 charges. We'll go through them as well. I've got all them lined up. We'll go through the charge that Aaron's facing. I've got a couple of short videos. Yes, Christine, live stream whatever you want, my darling. And then we'll also watch the gag order hearing as well. So, right. So let me just add this on stage. So this is from the Arkansas Times. So I'd rather go through this and go through documents. So let me see if I can zoom into this here. So according to records obtained by the Arkansas Times, Spencer, so Aaron Spencer, initially called 911 just after 1 a.m. on October 8th, 2024, to report his 13-year-old daughter missing. Spencer told police he'd been awakened by his dog barking, went to his daughter's room to check on her and saw she was missing. He said he suspected she was with Fossler, who is the predator, who is the piece of shit in this scenario, who was 67 years old, who had been arrested in July and charged with 43 counts, including sexual assault of a minor and internet stalking of a child related to Fossler's pursuit of Spencer's then 13-year-old daughter, people. Hello, Rehab. The arrest affidavit, I cannot say that word, affidavit. I can't say it, so give me grace. For Spencer says he went to look for his daughter and Fossler after calling 911 the first time. The Lonoke County, again, I can't say that properly, County Sheriff's Office contacted, again, I can't say this one properly, Cabot Police to ask them to check a specific address. Prior to hearing back from those police, however, 911 dispatch got a second call from Spencer, who said he had located the man who kidnapped his daughter and his daughter, but that Fossler was dead on the side of the road and that he had no choice. The affidavit contained Spencer's recounting of how the deadly interaction unfolded. Spencer saw Fossler's white Ford F-150 turn onto Highway 236 East towards Fossler's home. He turned around and chased after Fossler's vehicle, flashing his lights and honking his horn to get Fossler to pull over. When the two vehicles arrived at the intersection of highways 236 East and 30 North, Spencer rammed his truck into the rear of Foster's, sending the F-150 into the ditch. Good. I think it's coming out now, Lee. I'm not sure if it's still sealed or not, but I believe it's on the way out. It might be out already. Spencer then stated he exited his vehicle with his firearm in hand and ordered Foster out of his vehicle and to lay down in the ditch. Spencer stated that he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Foster had grabbed her and stopped her from getting out. Spencer then stated that Foster exited his vehicle and had something in his hand, but Spencer did not know what it was. Spencer stated that Foster then lunged towards him, saying, "Fuck you." Spencer stated that he then opened fire on Foster, emptying his weapon before jumping on top of Foster and pistol whipping him. Spencer then stated that he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. Hey, Huckster. I have got some of the motions, but I'm not going to go through them today. I'll go through them another time if we need to. I just want to go through this briefly. But yeah, some of the motions have been released, and they are sporadically being released as we go along. Hey, Hack. According to police, also, what I've just read so far, I just want to applaud Aaron Spencer. So I want to applaud him for what he did so far. He did what any, not just decent parent would do, but decent human being would do in that situation. He rammed into the truck. He tried to get his daughter out. The predator lunges at him. Bam, 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 bam. Absolute piece of shit. Get the fuck on the floor. As he should. And I don't mince my words with that. He did exactly what he should do in that situation. The guy just kidnapped his daughter. What do you want me to do? Just be, sit back. No. He did exactly what he should have done. Protect his family. So I applaud him for that. Hey, Zach, how are you doing, buddy? According to the police report, Spencer shot Foster in the chest, arms, and abdomen with a Glock 19 Gen 4 pistol. The report does not say how many times each body part was hit, though standard magazine for a Glock 19 holds 15 rounds. I wish it held more. They could have shot double that. Regarding the pistol whipping of Foster, the report notes that there was blood on the outside of the weapon when police recovered it. Good. Beat the shit into him. Spencer bonded out of Lonoke County Jail the following day. The case quickly drew attention both inside Arkansas and beyond. On November 27th, prosecutors charged Spencer with second-degree murder and commission of a felony with a firearm. The same day, Spencer's attorneys Erin Casinelli and Michael Kaiser issued a statement calling Spencer a decorated war hero, which he is, an absolute war hero. Hello, another CG. Hi, Rose. Reese. Hello, Reese. He is on bail. Thank you, Alicia. If you answer the questions in chat, Alicia, I appreciate you, my darling. So I can keep reading then. So Aaron Spencer is a war hero. So just put that. He is a decorated war hero as well. So put that into all this, They said Foster repeatedly violated his child and kidnapped her in the dark of night to continue his assaults on her. Tyler Jackson's nickel. The statement criticized prosecutors for bringing charges against Spencer at all, accused prosecutors of perpetrating these horrors instead of protecting legitimate victims and punishing true criminal offenders. Totally agree with that. And thank those who had voiced their outrage over the treatment Aaron, his child, and the rest of his family had suffered. We'll get into that a little bit further. Yes. Hey, Josie. Hello, Hot Mama. The following week, prosecutors asked Judge Elmer, which another mofo, Judge Elmer, she's the same judge that this predator who died, she was a judge in that case. She put him out on bond for $50,000. Shame on her for that. Absolute shame on you, Judge Elmore, for that. $50,000 bail for a guy who sexually abused and groomed a 13-year-old, and he put him out on that. No wonder she wanted a gag order in place to hide the mofo she is in all this. Absolute conflict of interest, Leisha. Absolutely. She's like Judge Bev. Doesn't recuse herself. She should be fully recused. And that's a good explanation. For those that don't know, $50,000 bail does not mean they have to pay $50,000. It means he has to pay $5,000 in cash. So that's, which is nothing to him. So it's $5,000 essentially. Oh, this judge gives me Judge Bev, and people that don't know who Judge Bev is, she's Beverly Canone from the Karen Reid trial, who did not recuse herself either. This judge should have recused herself because she was... Anyway. So, where have I gone? Where's my cursor gone? There. Elmore granted the prosecutor's motion. All right, hang on. No, Spencer's attorney filed a 19-page response to the prosecutor's motion on December 9th, less than 30 minutes. So, just to clarify this, right? They put in a gag order. The prosecutors did. Didn't basically, I think... Let me just double check this. So I'll come back to this now, right? So just so you know, the prosecutors put in a motion for gag order, right? So the defense team, Michael Kaiser, asked the court, the state just filed a motion for gag order. We would ask for 14 days to write the full response before the court rules on the motion. Response: the court will allow 5 days for the response. Thanks, Desi. Is that 5 business days? The court will allow 5 days. And that's all she comes back with. 5 days. Doesn't explain if it's business days or what. Hey, Brandy, how are you, my darling? So essentially, they had 5 days to put it in. Then, let's get back to the other one. Then, this judge who bonded that predator out for $50,000 took less than 30 minutes to decide and grant the prosecutor's motion. So a 19-page response, less than 30 minutes later, granted it. Like, a 19-page response. I know that people can read quickly, but that just tells you that she made the decision well beforehand. She wanted the gag order. This is only speculation. This is only my interpretation of this, right? She was the judge of this predator. As Alicia leads to, conflict of interest happened there. She wants this hidden. She wants this case hidden. She wants it buried. She does not want people to find out about any of this. She doesn't want to find out about the predator, that piece of shit. She doesn't want to find out about this case. She just wants it totally, fully buried. Gag order, my ass. For this. This is absolutely appalling. I did not know this bit. And she sealed all of Foster's charges. Protecting herself. Absolutely protecting herself. I don't know why else she's trying to protect, but she was protecting herself because she made such a horrible, and heinous decision to put him out on bail. She is partly to blame for all this. That I don't care what she says. She put him back on the streets. She put him, a guy who was grooming and sexually abusing children back on the streets for $5,000. And she allowed that to happen, and then he went and kidnapped said girl and probably tried to do all sorts of things to her and also probably try to kill her. That's probably the end game. Shame on you, Judge. And the shame on you, Judge, for not recusing yourself. She should be like, I'm just too close to this. I'm partially to blame for this, so let me recuse myself. Hello, Bad Dazzler. Yeah, she doesn't give a shit, Bad Dazzler, about anything except for herself. That's why was like plans to unalive Spencer's daughter that day. She was the only witness against him. So his quite. I'll be honest with you, Alicia, I've not really deep dived into the case. So if that's the case, then yeah, his charges maybe would have been thrown out. So that's why he tried to unalive her. My words are coming out badly today. YouTube are not going to be happy with me today. But my monetization is off, no ads, no nothing anyway. So all I ask of you, please go and donate to the Give Send Go. That's pinned description box. If you can give anything, that's all that's important here. And if you can share this video afterwards, that's also important, just to raise awareness, so right. Let me go back here. Spencer appealed the order, and in March, the Arkansas Supreme Court stated the case pending decision. Right, and we'll go into that in a little bit. So there is a pre-trial hearing on August the 8th, and thank you, Sarah P. And there is a 5-day trial set. So that, I think Alicia said it. I'm saying Alicia's name a lot today, but as I say, thank you to Josie. I did thank you at the start, Josie, you, Lady Di, and Alicia for getting me onto this case and everything. So thank you. Yeah, let's share this, share everything, the gag order would have prevented people from speaking about this, but now it's been lifted. Let's shout from the rooftops on this one. So because the pre-trial scheduling hearing is on August the 8th, which is literally next week. No, in 2 weeks. 2 weeks Friday. I don't know I hope that they live stream everything. I don't know if they do, but I do hope that they do live stream everything. We will definitely be covering it if they do. And the trial is scheduled for September 22nd. Now, that was the same date as what Stephen Stearns is supposed to be on, but obviously that's gone, so we will watch this now 100%. So again, hopefully, I don't know if this will be streamed or not, but hopefully it is streamed, so we can cover it. So that's where we're at the minute with everything. With that gives a broad overview, but it's not everything, people. It's not everything. Yeah, I think so as well. Probably she will deny it, Robin G. I hope she doesn't, but by sounds of it, she's a mofo. So she probably again wants to hide it because she doesn't want people to see how much of a shit job she's done. Right. So I will show you first of all. Now, don't let me forget about the police planting as well a pipe in the car. We'll get into that in a second. This is, I'll show you this quickly, then we'll go into the piece of shit predator. So this is the oh no, that's the wrong one. That's one I'll play in a second after this one. Where's it gone? Here we go. This one it is. This is the charge. So just so you see what they put in. State of Arkansas versus Hello Terry, Aaron David Spencer. I, Chuck Graham, prosecuting attorney who within and for the 23rd Judicial District of the State of Arkansas, which consists of Anoke County, in the name of and by the authority of the state of Arkansas on information accused the defendant of the crimes of murder to a Class A felony in violation of ACA 510-103 and felony with firearm in violation of ACA 1690-120 committed as follows. The state of Arkansas alleges that on or about October 8th, 2024, in Anoka County, Arkansas, the defendant for count 1 did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of human life, a Class A felony in violation of ACA 510-103. Michael Foster against the peace and dignity of the state of Arkansas. Enhancement charge is any person convicted of any offense that is classified by the laws of this state as a felony who employed any firearm or any character as a means of committing or escaping from the felony in destruction of the sentence in the discretion of the sentencing court may be subjected to an additional period of confinement in the state penitentiary for a period not to exceed 15 years in violation of ACA 1690-120. So those are the count and the enhancement of what they persecuted him on. Obviously, the defense have raised. Where's it gone? Hey, Dan from Atlantis. Notice of intent to raise justification as a defense. Comes now the defendant Aaron Spencer by and through his attorney Erin Cassinelli and Michael Kaiser of Lassiter and Cassinelli, and for his notice of intent to raise justification as a defense states and alleges as follows. 1. The defendant is charged with a felony offense. 2. The defendant does indeed intend to raise justification as a defense under Arkansas Code and 52604, 606, and 607 in the above reference case. Wherefore, the defendant is hereby giving notice to the state and the court of his intent to raise justification as a defense in this murder. There's, in my mind, we'll have to. I'm not going to do it today, but in another stream, I will dive more into the actual codes as they've outlined there. But I do not see how possible Aaron Spencer gets convicted. But right, so that's going to be his defense. So just to jump back a little bit, just so you guys know, so Michael Foster, the Predator. Hey, Misty. I agree. I mean, when I read this, without even knowing the laws of Arkansas, I'm like, I would do exactly the same. I think any defendant, you don't have to be a parent. Any defendant, any human being that's got a heart would have done exactly what he did. In my opinion, I would have shot the motherfucker if I was in the same position. It's one of those things where you might get one person who will want to convict, so you might get a mistrial, hung jury or something, but there's no way you get a conviction out of everybody. But what they will say, law of humanity, absolutely. But also what the court are going to do is the same thing they try to do currently, the same thing they've done to everybody, every defendant. They will try and bankrupt the defendant and his family. They will try and bankrupt everything they've got. That's why the give, send, go, people, is so important. If you could give any change that you have, it helps them, because unfortunately, the judicial process, these prosecutors don't give a shit. They've got unlimited money. Unlimited. The families don't. The families do not. The families potentially will be crippled with this, and that's why it's important to try and really shout them out and stuff like that. Right, hang on, where's it going to go? So these are what the Predator. I just want to call him the Predator. I don't even want to give him his real name. even though it's going to be on the screen there. He's a predator. Can you name the judge? She's part of the issue. This is why she shouldn't be sitting there. She's part of the issue. She's part of the issue, which is why he wants to, hide everything. The only thing that looks bad, if anything, is how many times he shot him and then he hit him with a gun. Yeah, I get it. I know you get it, though. I would have done exactly the same, though. To be quite honestly, I would have been like, bam, 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 just let it go. I'm not saying I would, but to me, I would like to think I would. So, Michael Fossler, case summary. Let me just, can I zoom in on this? So, Barbara Elmore, she's the judge in both. Offense. So, these are all the offenses. Internet stalking of a child. Internet stalking of a child. Sexual assault, 4th degree. Sexual offense, 4th degree. Sexual indecency with a child. Sexual indecency with a child. Computer child pornography. Pandering or possessing medium, depict sexual conduct child. Pandering or possessing medium, depict sexual conduct of child. Pandering or possessing medium, depict sexual conduct child. Disposition dismissed, defendant deceased. Pandering or possessing medium, depict sexual conduct child. Same again. This is all pandering or possessing medium, depicts sexual conduct child. Here you go. This is Arkansas. He was a former police chief in Hamlet, Indiana, but this is in Arkansas. You see, pandering or possessing medium, depict sexual conduct of a child. All of these. Look at this. This is what you get from a police chief. Pandering or possessing medium, depict sexual conduct of a child. "43 offences. 43. I'm unaware yet, Aaron Hack. The defense have put in a couple of motions, but I've not seen any prosecution ones yet. So this is also true. The blue will always back the blue. Wonder how many times he did when he was chief. This is a scary bit. People, I'll say this, right? This has come to the forefront. This is not his first rodeo. I can guarantee you it's not his first rodeo. I don't know the answer to that question, Mexi. I don't know the answer to that question. Did he break in or was a minor lured out the home? I don't. He broke in, okay. So, yes, I'm going to come into this one now, Alicia. I'm going to come into this one now. So this is a police chief from Indiana. This is not his first rodeo. He's done this many times before. Without doubt, he's done this before. But this is the first time he's been caught. So imagine all the cases out there from people that he's groomed, he's done stuff. This has got Sandra Birchmore vibes all over it. Sandra Birchmore was a case in Massachusetts where a young girl was groomed for many years by multiple police officers. In the end, a police officer allegedly killed her. She was carrying his child or alleged child and killed her. This has the same vibes. So Right. So that just gives you a picture of where we're at with that. Let me just take that down. Don't even look at that again. Count one's done. Hey, Tim. So, as Alicia led on to, there's more funny business that happened. So another article. I'll just read it very quickly, but then I'll show you the motion in limine. So just to confirm, Aaron Spencer is a combat war veteran. People just remember that as well. He's an absolute hero. Ooh, here we go. Where's it gone? Right. So when he got arrested, right, he was put in the police car, a cruiser, whatever you call it. He was pulled out by the sheriff, right, which we'll meet in a second in another video. He's pulled out by the sheriff, and he was put back in to the sheriff because the sheriff assured him, no, everything's gonna be fine, don't worry about anything, blah blah blah. It's then alleged that he or somebody, arrest or police officer, planted a pipe on Aaron, so a crack pipe during the pat down. So allegedly, again, just more corruption there from some of the police. They put up a crack pipe on him or in the car. Aaron found it. I was like, motherfuckers, he highlighted, screams at the top of his lungs. That is not mine, that is not mine, that is not mine, that's not mine. And obviously, they were like, no, it's probably yours. He screamed so much, like, I want a drug test and I want to test it. And he demanded a drug test to prove that that crack pipe was not his. So those police officers put that crack pipe on him in the car. Allegedly. There's no alleged, they did it. So when we say back in the blue, I know not every person in the police force would back all that, but this is how far they would go. Put a crack pipe in there. Why would you do that? Luckily, he was savvy enough to go, motherfuckers, no, I want a drug test, He had drug test, obviously he passed. And then the DNA evidence proved that his DNA was not on the crack pipe at all. It just makes you think, what's going on? How far will these people go to get him convicted? So although I appreciate not all blue and blue are bad, there are some really good police officers out there, but there's some shady, corrupt ones as well. I do not disagree with Huckster here, but I personally believe the judge is the main source of all this corruption and the rest are falling in line. She's part of it. There's no denying it. She's the one that's trying to bury this. She has that power. She tried to bury it. She should have recused herself the instant this came to court. She didn't. My fear is he's not going to get a fair trial out of it. Let's look further, right, into this. So this is the defendant's supplement to motion in limine to exclude reference to alleged glass smoking device found in patrol cruiser. Comes now the defendant Aaron Spencer by and through his attorney Michael Keel and Erin Cassinelli of Lassiter Cassinelli, and for the supplement to his motion limine state. So there's two. There's another motion they put in. This is the second one. The first one is just case law and stuff like that. This one is added extras onto that. Spencer supplements his original filing to provide additional information more recently obtained that bears on the admissibility of the evidence as at issue. The smoking device at issue was found in a patrol car at the scene of the shooting. Reports detail the events as they relate to the finding of the device. At the scene, an officer placed Spencer into a patrol cruiser, removed him, and then later placed him back in the other side of the patrol cruiser. When Spencer was placed in the vehicle, he noticed the device and immediately notified officers that he was already inside the cruiser when he was placed there. Spencer immediately denied it belonged to him and demanded a drug screen to prove he did not use drugs. He consented to a blood draw for this purpose. Although if the state ordered a test, the results have not yet been disclosed to the defense. In addition, the ASCL testing of the device yielded a partial male DNA profile that affirmatively excluded Spencer. So think about that. The DNA on it excluded Spencer. I hope they test all the police officers. Based on the information provided by the state, the evidence indicates a lack of sufficient connection between the smoking device located in the patrol car and the defendant, such that the state could not make a sufficient showing that the defendant ever possessed the item at issue to render it admissible pursuant to Rule 404B, or for any other purpose further, because all signs point to the device having been placed in the cruiser by someone other than Spencer. The risk of unfair prejudice and confusion of this issue is especially great. The question of how the device came to be the patrol car will be also unreasonably extend this trial in this matter. Accordingly, this court must exclude the evidence at issue. Wherefore, the defendant respectfully requests that this court enter an order precluding the state from offering any evidence about the glass smoking device during the trial in this matter. Oh. Lou, I don't know, Medallion. I don't know the answer to that question. So there's that. Shady. This is, again, a case. Yeah, and again, the judge makes or breaks the case, people. She can deny stuff. Like, look at Canone. Judge Bev, she did everything in her power to try and get Karen convicted. The Richard Allen one, we didn't watch it, but by all accounts, Gull did everything to try and get him convicted, and it seemed that this judge is going to try and get everything to get Aaron convicted. No accountability for judges. It's disgraceful, RJ. So there's two quick videos I've got to play here, just so that we can get. And Schroeder is another one, yes, for Zachary Anderson, another case that we should be appalled about. So this is back in 2024. You get to see the sheriff here. The sheriff is on this video speaking. Let's see what he's got to say.
Station that's on your side. This is Channel 7 News at 6.
Well, good evening to you. We begin our newscast in Lonoke County tonight with new information in the case of a father who allegedly killed a man he found with his missing 14-year-old daughter.
36-year-old Aaron Spencer was arrested on a preliminary charge of first-degree murder in the death of 67-year-old Michael Fossler. The Lonoke County Sheriff says Fossler was out on bond at the time of the confrontation after being arrested over the summer for internet stalking of a child and sexual assault. Channel 7's Daniela DeHogany has the story.
Aaron Spencer was acting as a father. There's no way that we're going to put the criminals ahead of our kids. Your kids, my kids, they're all our children.
An Arkansas father, Aaron Spencer, has been charged with first-degree murder following a shooting incident involving Michael Fossler, a 67-year-old man found with his missing 14-year-old daughter. The Lonoke County Sheriff says they responded to the initial call regarding Fossler in July.
Took a report of a inappropriate relationship, possible sexual misconduct, and we realized that was Cabot jurisdiction. We reported that to Cabot detectives. Cabot worked that case. He was subsequently arrested back in July, placed in the Lonoke County Detention Center. The initial charges was rape and internet stalking, and I believe other charges were added, such as child pornography.
Spencer called the Lonoke County Sheriff's Office the night of October 8th, reporting his 14-year-old daughter missing.
Hey, my daughter, I can't find her. She's not in her room. So initial call is a missing juvenile. Tuesday morning, about 1 o'clock in the morning. As we're arriving on scene, we get the second 911 call of a shooting.
While deputies were on their way, Spencer informed them that he found his daughter in a truck with Fossler. This led to a dispute between the two men, ultimately with Spencer fatally shooting Fossler.
And it was just down the road. Deputies arrived, investigators arrived. Mr. Spencer was detained because that was a homicide.
The sheriff says the investigation is still ongoing and is in the hands of the prosecutor.
My investigators have family, they have children. I'm a daddy. In a situation similar to this, I can't tell you I wouldn't act the same way. But now we are the fact finders. We don't file the charges.
Okay, the question for you, Sheriff. Why did you or one of your officers plant the crack pipe in the car? Can you answer me that, please, Sheriff? Why did you do that? Why did you bring him out the car, pat him down, and then put him back in the car with the crack pipe? Can you please answer me that question, please, Sheriff? Until then, shut the fuck up with all this. Like, you know, we're just the fact finders. You're supposed to be honest, integrity, and all that. But that does not. Hello, lovely. The jury is the fact finders. Just do your job. Why can't police officers just do their jobs properly and not try to plant evidence and stuff like that? How can he sit there with a straight face, with his egg-shaped face, and saying all this? I don't know.
We supply the information so the prosecutor can make a determination whether it was justified or not.
The sheriff says his thoughts are with both sides of the families, saying that the families of predators often do not know what the individual is up to. On your side, I'm Daniela DeHogany.
And again, Spencer was arrested on a preliminary charge of first-degree murder, but is now out on bond. This case is now in the hands of the Lonoke County Prosecuting Attorney's Office, which will ultimately make the decision whether or not to file formal charges.
It was on the seat. So basically, J-Mac, what happened was he, from what I read, he came out of the cruiser and was talking to the sheriff, got patted down and stuff, and then they put him around the other side. So say he came out on the left-hand side, they put him back in on the right-hand side, and he looked over, he saw the crack pipe on the seat where he was sat previously. Now, imagine if they weren't so stupid to put it right in there, and if they put it on the floor and he didn't see it or something. Then he would have got there, and then they would have found it, and then they would have been like, oh yeah, we put this into evidence. They probably wouldn't have told him anything for days, maybe. They would have just taken it, they maybe not doing any drug test or anything. So that piece of evidence would have been submitted because, well, can't deny it wasn't him. But the fact that he saw it and kicked up such a fuss means that she shouldn't be allowing that in, because that's, well, I mean, the defense is going to say it's planted. But the problem we have is when you tell a jury that the police are corrupt, what happens? Lots of people don't believe the police can be corrupt. They don't believe stuff like that could ever happen. I bet you the RJ, the dash cam footage is poof, disappeared. If you think about it, until the Karen Reid case for lots of people, you would never believe that police could be so corrupt as they are, but they are. They really, really are. Not everybody. There's some. I hate this because there are lots of great police officers out there, but don't forget there are some shady ones that will do anything to pin it on a defendant. This is why there's so many defendants sitting in jail innocent right now, because of shady police officers, like it seems this county has. Makes their case easier, yes. So this is after he enters a plea. So this is his lawyer and Aaron. So it only takes a few bad apples, absolutely. I'll be back now in a second. Let me just put this up for you. Hello, Crystal. How are you, my darling? Just noticed the
second-degree murder charges. Aaron Spencer is charged in the deadly shooting of 67-year-old man he found in the car with his 14-year-old daughter. Rebecca Brown was in the courtroom today and has the latest developments on a case that got a lot of national attention.
Aaron Spencer is not a criminal.
Monday morning, Aaron Spencer uttered the words "not guilty" in front of a judge at the Lono County Sheriff's Office, where he is facing charges for second-degree murder. All this because of an incident on October 8th, where police reports say Spencer's teenage daughter was missing and was discovered by Spencer in a car with 67-year-old Michael Fossler. According to the sheriff's office, this eventually led to an argument ending with Spencer shooting and killing Fossler.
He was absolutely fearful for her life. Not to mention that she had been repeatedly the subject of multiple assaults, violent assaults on a child. What are we doing here?
According to court documents, Fossler was charged in early September with 2 counts of sexual assault and 2 counts of sexual indecency with a child, along with several other charges. According to Spencer's defense attorney, Erin Casanelli, in her words, he did what any parent would have done.
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
But according to prosecuting attorney Chuck Graham, who charged Spencer with second-degree murder, Spencer's fear is only part of the story.
They had a lot to say about the situation and me, but what's being put out there is not the whole story. And ethically, I can't go much further than that.
Outside of the sheriff's office,
it's diabolical. I can say that he knows everything's going to be sealed. He's like, oh, it's not what you've heard yet. You know, the diabolical what they say about me. It's diabolical you even charged him. Think about that, dude. It's diabolical that you even charged Aaron Spencer for this. Has he no heart? And the judge has protected him by putting a gag order in place. That's what is scummy.
Good family and friends of Aaron Spencer. This case catching the eyes of people beyond Lono County, as many Facebook comments feel as strongly as both sides defending in the state versus Aaron Spencer.
And we look forward to the public being involved in this process, certainly more so than they were today.
A trial date will be set sometime out in the future for a jury trial, and we'll go from there.
That was Rebecca Brown reporting. Now, the judge set a date today for Spencer's trial and scheduled jury selection to start next March 19th.
So, just think about that. This happened in October. That video was, when was that video? Oh, I don't know when that video was. It would have been, was it December? Hang on. Let me find out here. Hang on. The gag order which I'll go into in a second. Where is this though? So the judge initially on the 4th of December said that pre-trial would be 17th of March, and the trial would be on the 19th of March. So essentially, she said, yeah, there we go. This is going to trial, but you've only got, what, January, February, March, 3 months. 3 months to prepare for a murder trial. Why is she rushing it? Why was she rushing it so quickly? A murder trial doesn't happen in 3 months. It's very rare that something like that would happen in literally 3 months. Or she just wanted to get this over and done with quickly before the media got to it. Let's get in, get out. Let's get it done. It just begs the question. It just makes you think, what's going on? Why are we here? Why is it being rushed? I understand speedy trials, but even 3 months, speedy trials take longer than that. Yeah, hide it before it gets too much attention. Absolutely. So this is the gag order. This was put in place on the 10th of December. In view of the apparent public interest in this case, I'm not going to go through it all, but just give you the gist of it. And the extensive news media coverage, well, there is, because this is a high-profile case. As a result of such interest, and because it appears to the court that the dissemination by any means of public communication of any out-of-court statements related to this case may interfere with the rights of the defendant and the state of Arkansas to receive a fair and impartial trial, and further seek a fair balance between the constitutional guarantees of a free press, the following order is hereby entered. Right. I would like to know, has she done this at all for other cases? Is this her ammo? Is this her ammo on everything? Where she bans the press for everything? I'd be interested to find out. It's no doubt in my mind that, where's it gone? Oh, it won't let me do it. No doubt in my mind. No, the trial is this year, Christine. It's in September, my darling. That this is not put in place because it's interfering with the right of the defendant. This is put in place for the benefit of the judge. This gag order. I have no doubt about that. This is fully about her. Because just remember, for those that are just coming in now, she put the paedophile, the predator, out on bail. He only had to pay $5,000 to be out on bail. And then he went hunting. And he probably had every intention to either do some stuff to her again, or even to kill her, basically. Because without her, there's potentially no case. Obviously, unless he's then tried for murder. But, that's another thing. So I've no doubt in my mind that she is not interested in the defendant getting a fair trial. She's only interested in her back. Is my my guess. There's some good deep dives. I've not watched them, but I've heard he goes into locations and stuff. So that's another one. Carnage on Ice. I have seen them. I need to go into them. He's more local, I think. And also, it'd be remiss of me to say, people, keep an eye out for one special episode about this case where it's going to be even better than this. It's by the beautiful ladies on Wrongful Pod. They will be doing a deep dive much better than I can do a deep dive. So make sure you listen to that as well. Oh, he's from Canada. Thank you. There you go. So it is the order of the court that no party to this action, nor any attorney or agency connected with the case, directly or indirectly, nor any judicial employee or officer of this court, nor any public official now holding office, including but not limited to law enforcement officials, nor any agent, deputy or employee of any such persons, nor any person subpoenaed to testify at the trial of the case. Neither shall the defendant nor his family shall do any of the following with, yeah, let's stop the family from speaking and showcasing that he actually shot and killed the predator who was grooming and assaulting their daughter. Let's not tell the public that he did what any decent human being would do. Let's do that. Let's hide the fact that a predator was killed by father protecting his daughter and his family. So no one shall release or authorize the release of public dissemination of any judicial statements of defendant relating to this case. Release or authorize the release of any documents or exhibits or any evidence, the admissibility of which may have to be determined by the court. Make any statement for public dissemination. I can't say these words half the time. As to the existence or possible existence of any document, exhibit, or any other evidence. Express outside of the court an opinion or make any comment for public dissemination or as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. Make any statement outside the court for public dissemination as to the weight, value, or effect of any testimony that has been given. English is my second language, so bear with me, people. Issue any statement for public dissemination as to the identity of any prospective witness or their probable testimony or to the effect thereof. Make any out-of-court statement for public dissemination as to the weight, value, source, or effect of purported evidence alleged to have been accumulated as a result of the investigation of this matter. Make any statement for the public dissemination as to the content, nature, substance, or effect of any testimony which may be given at any proceeding related to this matter with any attorney of record or any agent thereof. Hello, Jilly Beans, by the way, beep beep. This order does not include factual statements of the defendant's name, age, residence, occupation, or family status. The circumstances. So you're happy for defendant to be put out there. You're happy for the defendant to be out there, his name, his family, everything. You're happy with that, but not why he's killed somebody. Okay, I understand that. Stupid motherfuckers. The circumstances of the arrest, namely the time and place of the arrest, identity of the arresting and investigating officers and agencies, and length of the investigation. The nature, substance, and text of the charges, including a brief description of the offence charged, quotation from or any reference without comment to public records of the court in this case, of the public records or communications heretofore disseminated to the public. So basically, the scheduling and result of any stage of judicial proceeding held in open court and in an open or public session, any request for assistance in obtaining evidence, discussion by us of any matter, with the case with any of the attorneys representing the defendant of the state, all parties, and the defendant is something, I don't know what that says. A copy of this order will be attached to the subpoena served on any witness in this matter, and the return of service of the subpoena shall include the fact of service of a copy of this order. In addition to any information violating this order shall be redacted from any paperwork related to the case, and might be disseminated to the public. The order shall be in force until this case has been disposed of or until this court orders otherwise. This order will help ensure all parties get a fair trial. The online case is now sealed. Right. So what this judge is saying is, I don't care if you put the name of the defendant out there, that he killed somebody, and who arrested him. We don't care. Just put him out there. But whatever you do, don't say what the defendant, what the victim was, why he did it, what the victim did to this guy's child and everything. Just tell the public that this guy killed somebody. Let the outrage get out there. Let the outrage be out there. And you know what? I'm not going to stream this case because it's not going to lead to a fair trial. So let's make sure the public only know that this guy is a piece of shit for shooting and killing somebody, and then let's not say anything more about it. Let's hide it. Let's not tell anything. Let's have the trial. Let's keep it quiet. Let's get him found guilty, and then we'll move on. That's what that is, in essence. All the jargon and stuff like that, that's the judge saying, I do not want the defendant to have a fair trial. I want, this defendant to be found guilty. That's it. And I want it to be hidden that I put this guy back on the streets to go and abuse the same girl again and possibly kill her for his own benefit. I don't want no one to find that out, people. I want no one to find that out. It beggars belief, This is not what the judicial system, anywhere in the world, not just America, anywhere in the world, people should be outraged about this. And she gets away with it. She got away with it for months. She tried to put a speedy trial in place. She tried to get on the 4th of December, saying there's going to be a trial in 3 months. Be ready. Don't give a fuck if you're not ready. You better be ready. 3 months, done. And do not tell anybody what this case is about, or that I let the convict out on bail for $5,000. And that basically it's my fault that he's out there. So the defendant, Aaron Spencer, is out on bail. He got a bail $150,000. The predator, who molested and groomed a young girl, was out on bail for $50,000. Think about that, $50,000 he was out there for. He's an ex-police chief in Indiana, and he's out there. Oh my days, this is disgusting. Right. One more time, I'll show you this, and then we'll get into the... I'll show you the actual gag hearing as well. So again, this is a give, send, go. Oops. Is this the right one? Yes, it is the right one. Supporting Spencer family. I am making this campaign for my sister and brother-in-law, Heather and Aaron Spencer, and their children as they navigate their lives after the devastating trauma they've been through. This is for their personal use, such as therapy measures and keeping their family afloat amid Aaron's daunting leading proceedings. Beginning in the spring of 2024, my then 13-year-old niece was targeted by a predator, groomed and assaulted multiple times. The Spencers were silently suffering through the slow process of justice as this monster was put in jail, then immediately released on a low bond with zero. I'm looking at the screen on this side, so sorry, that's what I'm doing. Low bond with zero supervision and no contact order. And yeah, just remember, he had a no contact order. Then immediately released on a low bond with zero supervision, no contact order. He was awaiting arraignment for the multiple felonies he committed against my niece, and she was expected to testify. So that's why, I think that he went to her trying to kill her so that she wouldn't testify. In the early mornings of October 8th, my sister and brother were awakened in the night to every parent's worst nightmare, a missing child. They immediately contacted authorities, and then Aaron did what any good parent, and I may add, any good person or good human being would do. would do, he got in his truck and went out looking. By some miracle, my brother-in-law passed the predator with his underage child on the road. A chase ensued. If you're familiar with our family story, you know what happened next. In protection of himself and his daughter, the night she was kidnapped, Aaron shot and killed the predator. Again, he deserves a medal for that and deserves a statue for that, and was subsequently arrested and is now awaiting trial for second-degree murder, although he was clearly within his right to protect his family. Unfortunately, that wasn't the end of the nightmare of the Spencers. There was immediate outrage and media coverage, but as soon as Aaron was officially charged with murder too, the same judge who released their child's predator back onto the streets to ultimately re-offend also signed off on a vague gag order limiting media and state officials from commenting on their story. When the state placed the vague and unlawful gag order, it had a twofold effect. First, Aaron incurred more legal expense in fight this unjust order. Surprise, surprise. That's what they do. Second, we lost national coverage as the gag order sealed the case and prevented further reporting on it. Now that Supreme Court has vacated the order, we can speak freely again about the horrors our family has had to endure in the past year. First by their child predator, and now by the people who have sworn to protect and serve the interests of the community. My purpose of opening this campaign is to help the Spencer family feel secure in some way. Very challenging, uncertain time. From the original assaults to the night of the kidnapping, and now dealing with mistrust in the local justice system that didn't protect their daughter while persecuting her father, a combat veteran, was forced to. The Spencers have a lot of trauma to work through. Absolutely, they do. Yes. They have been spending hundreds of dollars a week on different therapies for their daughter and themselves, all suffering with PTSD from the events that has transpired. These therapies have been helpful, but they have a long road to healing ahead of them. And I would like to take as much financial burden off them as possible. They have been so humble by the donations they received for Aaron's legal defense, but we were not anticipating how much it would all end up being, especially after needing to fight against the gag order. Bullshit this is. They should never have to fight against a gag order on top of a criminal defense. Please consider donating to their livelihoods, as their journey to healing will go beyond Aaron's verdict. And please, above all else, keep them in your prayers. Pray for justice, for peace, and for healing. Thank you. You know, I did not know that. Absolute poor family, what they're going through. Right. So that's why if you could donate, that'd be greatly appreciated. So this is what I'm going to play now, is the actual gag order hearing. Gag order hearing here, right? I'll play this here. So we got this. So this has already occurred. There's a bunch of judges that well, you get to hear here basically anyway, from everybody that's a part of it. But yeah, let's play this in its full entirety now then. Let's take a look. Some of you might have seen this already. If you have, I'm sorry, but I think it's better to show you all what really happened than, you know, read documents and stuff like that. Right, hang on, let me go. Let me just move this so I make it bigger for you people. Nope, not that one. Not that one. Let me move myself up here. And then I'll make this bigger. Crap, hang on. I just want to play about with this for a second just to make it. There you go. All I'll do is I'll move myself up here out the way. Right, here you go, people. Let's go.
Thank you. Are there any motions from attorneys or parties present?
No, Your Honor. No, Your Honor.
At this time, then, we will take up the oral argument scheduled for this morning. CR 2566, Aaron Spencer versus State of Arkansas from Lonoke County Circuit Court. And I acknowledge the petitioner's attorney to come forward. Ms. Casanelli. And you've reserved 10 minutes for rebuttal, is that correct?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel. I'm Erin Casanelli, and I, along with Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below. We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important. This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was assaulted, sexually assaulted, severely, by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So, counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir, and thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding, and that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and this is a public hearing. So, and it's live streamed, it's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order is so overbroad that I don't know that I can answer that question precisely. My belief is that this court has asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument, all of the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him, and can raise it presumptively as to counsel. But as to anybody else covered by this order, what is what standing do you have?
Yes, sir. There are several things that sort of fall into that category, but as a general matter, the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. Here, your argument is it's not constitutional as applied to you, so I'm a little bit confused how we get to overbreadth.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases
Are there cases that treat overbreadth that way? I mean, I'm not familiar with any Supreme Court
No, that's
cases.
a bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, you know, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech, and most often the defendant doesn't want the speech, but the press is still.
I'm just going to say here, I like the fact that they're asking questions as we go along. I thought I'd be annoyed by that, but actually I like it because they got questions, so they're asking straight away. I like it.
Allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
Then I guess my question is, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief, and that's why you've argued overbreadth? Because normally if we said it was unconstitutional as applied to you, the analysis would stop. There's a stack of First Amendment cases that say that. The analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficiently clear, that indicates a substantial compelling interest, that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation of this question then. What I took some of your arguments to be framed as, yes, they were sometimes framed in terms of overbreadth. I thought maybe you were making a facial challenge as to the gag order itself and just arguing it's unconstitutional in all of its applications. Am I wrong about that? Or?
That's a tough question for me to answer. I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, and for the overbroad.
But that sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreadth challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreadth challenge at that point. So which is it if you're talking about other people?
Well, the point that I'm trying to make is I think that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis. I think that
Counsel, what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech, it was his receiving speech as well. And is that why it in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the affidavit of arrest or the charging document aren't public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it, I mean, putting too much emphasis on one point. I mean, courts seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal their records.
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence that you obtain in discovery, then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea. The public was prevented.
Read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment. I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment?
I can't swear to that because my back was to them, but I watched the bailiff and heard him tell numerous members of the public that the court had ordered that only 2 members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people, and it wasn't 100 people, it was about 8 or 10, and he turned them all away.
But counsel, we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond voir dire. We haven't extended that to arraignment and further.
No, Your Honor, I'm not, but it is an important consideration here because Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fossler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send this back to Lonoke County Circuit Court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and to provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction, and order the circuit court and all circuit courts to conduct such analysis before they impose a gag order to ensure that it is appropriately narrowly tailored only as is necessary to prevent substantial prejudice. That's what I'm asking for, and in this instance, the circuit court undertook no analysis, took no evidence, so there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, which, and which case does that come from? I mean, I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from? What is the closest match? And is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public interest.
But the balancing language, where does that come from? I'm not familiar with a case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does it actually apply a balancing test as one would traditionally think of it, or does it just say we balance in formulating the standard, we balance the interest? Or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, you know, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that. It's going to be different. Do I take from your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it? No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily has to be specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue into your rebuttal, or
thank you.
Thank you.
So she obviously gets a rebuttal.
To respondent.
So if you weren't aware, she starts, the prosecution come in now, and then she will come back with her rebuttal at the end. But what do you think? I'll put a poll up, see what you think. Do you like the judges asking questions as they go along or not? I'll put a poll up now to see.
Thank you. Madam Chief Justice, and may it please the Court, I'm Assistant Attorney General Joseph Carl Lupke, here today on behalf of the respondent, the State of Arkansas. The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. Reviewing this order and Spencer's claims under the intermediate scrutiny standard set out in Gentile versus State Bar of Nevada.
Counselor, what would be the harm in sending this back to Circuit Court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here. It is undisputed, they didn't dispute it below, they haven't disputed it here, that there was sufficient media attention, expansive media attention, that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And then the other thing you have is the statement that was attached to the state's order, which represented an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather in the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here? I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said cryptically. Like, that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Bronny. But I think when you read that statement, you can see the intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record. The fact that the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so this court, the circuit court, needed to ensure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury,
That's
right?
correct.
And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counselor, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quickly, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As quickly as I can, Your Honor.
If you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court, and it had the opportunity to consider it, so I think we can find an implicit finding here.
Let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020 in the Arkansas Democrat Gazette case when they brought a writ of cert to this court. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level. And so that's my question is why would we treat it any different than the case we vacated in 2020?
I think you're dealing with who's making the petitioner here. The petition is the defendant and not the press, and we treat press cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was exact, I mean, same language.
I'm not aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here with the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
For purposes of the defendant's counsel, perhaps, but one, it wasn't a prior restraint, right, in Gentile, so that's different, and that was a case about defendant's counsel. Here, I think you concede, correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, some of its language said because lawyers have special access to information through discovery, client communications, extrajudicial statements, their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the entire attorney's speech. He was then subsequently punished. But I think it can be viewed as a prior restraint case.
So that one, you could make the argument in Gentile that was people directly connected. There is language to that effect. But here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, while I say that public officials may be broad and probably could be reformed, the idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge who were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning I sat in my office and discussed this case with the 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not?
Your
Because
discussion,
it says any public official now holding office.
Because the restraints in the gag order are for public dissemination. Your discussions in your chamber are private. And in fact, they're exempted from FOIA. You have a right in crafting opinions.
Facebook post by the Lieutenant Governor. Covered, not covered by this gag order.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
When you say inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think it was. I don't think that claim is before this court.
So your boss is the Attorney General. Every legislative session, the Attorney General has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that, so he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding and
Okay, so
representing
let's say
this
it's the governor's package.
I think the
Did
governor...
the governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, it's the general proposition of public officials is probably too broad and should be reformed.
So what about family? Whose family? Is that spouse and kids? Is that the 4th cousin you met once at a family reunion 30 years ago that's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that we that perhaps that was not something the state requested. That's something the circuit court did on its own. I do think it is appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his wife or his mother or people that they would see as authoritative. But I think it would be appropriate.
Then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused as to the position.
I'm sorry, could you repeat that?
So the first here is basically you can't launder the statement provision. Any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision, or?
I think the order says that the family is a restrained party and that is a restrained speech, so I think that would apply. I think that's a fair reading of the order.
Counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected.
But
I think
then why is that necessary if you can publicly say the arresting, investigating officers and agencies are public and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
I think that, first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers could be witnesses for either. And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair trial for who?
A fair trial for the public and a fair trial for Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Can I ask about the overbreath thing? Because I'm not sure that I got a clear answer from opposing counsel about whether they're raising an overbreath challenge, but it's certainly in their brief. What is your view of how we would conduct that inquiry? Because normally you have a statute, it's very clear, there's one standard that would apply across the board. It might be unconstitutional, or it might be constitutional as to a particular person before the court, unconstitutional as to others. Here, assume for a second with me that the court has set different standards for different people, or certainly different articulations of the standard for different people. So what do I do on the front end to determine whether or not there's substantial overbreath? Do I have to go through every group in the order and apply a different standard and say, well, it's okay here, it's not okay there? So I add them all up and somehow it's substantially overbroad? Or how do I do that in the state's view?
I'm not sure I can answer that question. And I think your question demonstrates why an overbreath challenge isn't appropriate here and wasn't raised here. They're raising separate challenges as it is to his speech, as it is to the other speech. They're raising a bunch of different as-applied challenges. They don't have standing to assert it on behalf of those other parties, and that's the problem. And I think that there is a possibility that different standards could apply to different parties, which wouldn't lend itself to an overbreath challenge.
And then,
the general public, sorry.
On that standard then, I guess, what is your view of what Gentile says and what Nebraska Press says, and what is the difference between those two standards?
Nebraska Press is they deal
with different people, I'll give you that, but other than that, what is the difference in the articulation of the standard?
I think not only do they deal with different people, they deal with different First Amendment rights. One is dealing with free press and one is dealing with free speech in the Constitution. I think that open press, they talk about there being open discussion in this case in the public. We view that with much greater scrutiny in the law. Whereas the trial participants, what Gentile has said, what Shepard has said, and what Nebraska Press has said, are viewed under a much lesser standard because it gives the court room to balance a fair trial versus those First Amendment rights.
So why does the different standard matter here? Because as I understood your articulation of the interest here, I think your view would be that you survive strict scrutiny. So, what is the relevant difference in the standards here? Because you started by saying this is intermediate scrutiny, so you obviously care about the standard. I guess I'm trying to figure out why does that matter here then?
Well, it matters here because not only are we trying to ensure a just result in this case, but we're setting the standard going forward and for future cases. That's what this court does. And I think it matters specifically where intermediate scrutiny versus strict scrutiny matters in this case is when it comes to what narrowly tailored means, and specifically the consideration of least restrictive means. Under intermediate scrutiny, this court does not have to, or the circuit court did not have to choose the least restrictive means of choosing its goal.
That's generally true, but doesn't some of the language in Gentile indicate that maybe this is like intermediate scrutiny with a bite almost?
No, I didn't read it that way at all, Your Honor. I think the language specifically said that the court doesn't have to rely on things like voir dire and a change of venue because those will come after the damage is done. We don't know and cannot know, that as Nebraska Press, the known and unknowable, whether or not they will be sufficient to do the job. And given the primary constitutional duty of the court is to ensure a fair trial, it's important that they act prospectively.
So your primary interest then is in avoiding tainting the jury pool? That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in the order about the identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified? What purpose does that possibly serve with respect to either the jury pool or intimidating witnesses?
I think it depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to read press accounts.
It feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
I think the circuit court had all the information it needed in front of it to craft the order that it did, and I think that order is narrowly tailored. It specifically targets public dissemination of the evidence in this case, and just that, and that's to prevent
and the fatal flaw with that is that we vacated a virtually identical order in 2020.
And I think that Gentile would say that
well, it doesn't really matter, does it? That's U.S. We're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that we
can give more protections, correct?
We can give more protections. They did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it.
It's hard to do without a hearing, isn't it?
I think they could have developed it in their briefing. They had a full briefing schedule. This court requested additional briefing.
But would it matter if that prior order from this court was a syllabus entry instead of a reasoned opinion?
I think it does make a difference, because I think the important thing today, and what I would say in closing, is we want to adopt a good standard moving forward. It's important to ensure that justice isn't done in this case, but this court's opinions matter going forward. And so I would ask this court to adopt the Gentile standard because it gives the court room.
Counselor, I know you said you were closing, but I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
It means that the public docket and the docket entries are no longer public. That's what I took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? What do we have any extrapolation somewhere else in another document from the judge to kind of expound on what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the order before this court, And I think when we talk about sealing, I took that to mean sealing in the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen. I'm out of time. I would ask this court to deny the petition for writ of certiorari. Thank you.
I'll just add here, right? Normally, lawyers, attorneys like to speak, right? And they don't stop speaking until they're told, look, you're out of time. That's happened to the defense attorney. This guy made a point of saying, oh, look, I'm I'm out of time. I will just make if you could deny it. He wanted to get out of there. He was like, get me out of Dodge. I'm done. There's no way he would have said, oh, I'm out of time now. Unless he was like, I'm done. I'm gone. Judges, I would love to stay here and answer all your questions, but unfortunately, my set time is done. That is a sign of, get me out of here. Get me out of here. Right, the rebuttal. Let's listen to the rebuttal.
Counselor, as it applies to the other party, the non-parties and the non-participants, so essentially the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them, by having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lonoke County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration, and it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The cases that you're referring to that do that, they generally do that either because it's a press case or because it's an overbreath. So take Murphy Brown, for instance. Judge Wilkinson's opinion basically just says, we're applying overbreath analysis, never does sort of a preliminary determination of how that would work. So the same question that I asked the state, how do I conduct that analysis? Do I have to do some different test application? Assume with me for a second that I disagreed that strict scrutiny automatically applies to all of it. If I have to do that, how do I do that analysis, sort of the preliminary front-end analysis? Or wouldn't it have been easier to frame it as a facial challenge?
I think you can tell that I think that's a tough question. I think that there are different standards that apply, and unfortunately here none was applied. So any standard would be better than no standard, but I think the court does have to consider what burden must be met to prevent non-parties from speaking. I don't disagree with the state that trial participants can be restrained in ways that are more substantial than third parties, people who are not within the proceeding. I can't legitimately dispute that. But the cases, Nebraska Press, Shepard, they don't articulate for lower courts how to do that. No Supreme Court case does. which is why we're having this discussion and why there's not a defined answer to it. But I think the circuit court has a duty to take care to address those categories of persons in specific ways, because those rights are different and they are to be evaluated differently. I want to be sure to state to the court, there is no case that applies intermediate scrutiny to gag orders to this circumstance. There just isn't. There's no case that dispenses with the least restrictive means analysis. Gentile does not do that. In that case, it was a subsequent punishment at issue, not a prior restraint. That cannot be reasonably disputed. The Supreme Court has told us that those things are viewed differently and prior restraints are...
It says that, but when have they ever actually indicated how the standard is different? I mean, I recognize you're entirely right. The court has said prior restraints are treated differently. Tradition in this country, we treat them differently. But when it comes to actually analyzing them, can you point to the delta in the way that the court has treated them differently?
Yes, I think the court historically has consistently held that prior restraints are what they call freezing speech as opposed to chilling it. Because when you speak in the face of a rule that tells you, of an ethical rule, you are aware of the danger in doing so. It's very different.
I agree with you in those general terms, the court has said that, but where has it applied a different standard?
I don't know that that's specifically come before any court. I mean, I cannot think of a case where that has been specifically addressed. In my mind, that is something that is stated repeatedly. The evaluations of rules, like the ethical rule in Gentile, have been evaluated slightly differently. I would say this as it pertains to Gentile in this analysis. That, because it was a regulatory rule, the court was looking at the systemic issues. So the court was looking, they didn't dispense with the least restrictive means. They didn't have a case to apply that analysis to. So in that instance, they're looking at a rule. Is this necessary in a profession that we as a state license? Can we impose this ethical responsibility? And how does that rule affect sort of the systemic costs that may be associated with it? In a case in a trial court, I mean, we don't hear circuit courts say, well, you know what, we're not going to do extensive voir dire because it's too expensive. You know, we're not going to change venue even though maybe a defendant's entitled to it because it would just be too much of a cost on the system. I mean, Gentile is obviously dealing with the overall systemic assessment, but within the First Amendment analysis.
Well, counsel, I think what the state was saying is that they thought that perhaps some of what you said in a statement you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court. You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court. That statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact that. Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually, in full context, was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were. But the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. But I submit to you that there's really nothing in that written statement that should be even prejudicial. Even under the current gag order, his occupation, his family history, all of that is apparently okay to speak about. Public records are okay to speak about, and those are based on public records. So, I mean, just because the prosecutor doesn't like it, that is not a reason, that is not a justification for a gag order.
So if we construed this order narrowly, I realize it might be somewhat difficult to do, and just treated it as a poorly written order and construed it as most of the provisions have to do, I mean, there's the one about extrajudicial statements of the defendant, but otherwise, for the most part, what we're talking about are public dissemination or public comments about evidence, prospective witnesses, testimony, etc. If that was construed narrowly to be limited to statements about that are aimed at basically tainting the jury pool, releasing evidence, commenting on evidence, that kind of thing, does that give you the relief you actually are seeking, or is that not enough? And would that pass? I mean, the other question is whether that pass is relevant test.
It's difficult to answer that in the abstract. This order says things like possible existence of evidence. Like, I don't know what the possible existence of evidence is. You know, if we could define those contours better, then perhaps so. But, you know, some things that are potential evidence or possible evidence should be fair game for the public to learn about, too. So I think we should be narrowing this to prejudicial evidence, not anything that possibly could ever be evidence. And not all of this order addresses even public dissemination. And I'm sort of unclear even what that term encompasses. You know, social media is a big thing. There was lots of comments on social media. If family members have private social media accounts, is that public dissemination?
Does it matter that the state conceded that a Facebook post would be covered by this order?
The state in its briefing suggested so. I'm not sure I agree with that. I think that may not be public dissemination. I've been asked these questions and I can't give the answer any more clearly than anybody else from reading that order. I want to point out to the court that we do dispute the extent of the media coverage, the undisputed nature. Everything is in dispute here. Yes, there was media coverage. I don't think it was near as extensive as I've seen in many other cases, but we don't know because the court didn't take any evidence, so there's no basis for that statement. There's no basis for the statement that our written statement was the cause for the gag order. Nobody even alleged that in the motion. Nobody found that in the order. So I don't think that that's a fact that the court can rely on. I also want to suggest to the court as to the standard, and by the way, there's no evidence of risk to witnesses. No one has even raised that. That was commented on a moment ago. I don't know where that came from. There's been no allegation of that, no indication of that. But as to the standard, I do not deny that Gentile may provide some general baseline test for trial participants, but it cannot be the only expression of a test because of the limitations that we've discussed previously as to the regulatory nature and the lack of prior restraint. I think the court has to consider the heavy weight of the First Amendment rights that are at issue and honor those. And here, Aaron Spencer's not asking for a gag order. It's his Sixth Amendment right to a fair trial. And that is usually raised by the defendant in cases where the defendant attacks a gag order. We are not doing that here. So there's not a Sixth Amendment right as competing with a First Amendment right, as is discussed. I think Nebraska Press talks about how the founders didn't tell us which one should win the day. But that's not the issue here. The public has a right to a fair trial, sure, but they also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
Thank you, Evil Queen. Look at those chairs. They're nice chairs. Aaron Hackey would never fit in one of them. You have to be over 5 foot to fit in those chairs. Yeah, so just to clarify some stuff, Alicia's been doing it in chat, doing an awesome job. We don't actually know what else there is. You know, we don't. Sorry, Erin. We don't actually know what else there is. There's a lot of stuff still being sealed. There's a lot of stuff dripping in at the minute, as and when. So there's a lot more still to come. I like that. I like that. That's the first time I was hearing it as well. I like that. The back and forth asking questions. It's important to do so because it offers a lot of transparency, I think, in where they think it is, and put them all under scrutiny there and then. I'm sure as attorneys, they're not really. Well, the prosecutor did not enjoy it because he was ready to get off the stand. He was like, "Get me out of here right now." I think this is a tragic case that I think we say this for all cases. If this was in another state, it wouldn't be going to trial. We said the same thing about Karen Reid. If this is another state, it wouldn't be going to trial. I think this judge is showing a lot of bias and stuff. So I'm not very impressed by the way she's dealing with it. So there is a 34-page document, which I'm not going to go through, obviously. This is the joint conclusion from this hearing, which I'll go through here now for you. I mean, I'm sure a lawyer, will be going through a lot more of these than I will, but I don't feel like I need to. Conclusion. So from the gag order, the Circuit Court's gag order is far too broad and too restrictive of speech protected by the First Amendment and Article 2, Section 6 of the Arkansas Constitution. It is also impermissibly vague. Further, the order was entered without the requisite findings discussed above and wholly without a factual basis. Therefore, we hold that the Circuit Court's order constitutes a plain, manifest, clear, and gross abuse of discretion for which there is no other adequate remedy. Accordingly, we issue a writ of, I can't say that word, certioria, whatever, and vacate the order. Good. By this ruling, we do not foreclose the possibility that, after an evidentiary hearing, which is normal, the Circuit Court may issue subsequent gag order narrowly tailored to specify to specific factual findings supported by the record. However, we emphasize that a gag order should be a last resort, not a first impulse in regard to Murphy Brown LLC 907 F3D Act 800. Petition for writ of certiorari, whatever that says, granted, writ issued, Circuit Court's gag order vacated, Wood, Womack, Hilland, and Brony, JJ concur. So, there you go. You can look at all that. There's 34 pages. As I say, I'm not going to go through it. There will be, hopefully, people like lawyer, and stuff will be going through in that more in depth. I don't feel like I need to and pretend I know what I'm talking about. But that's the conclusion. If she wants to re-put the gag order in, the recommendation is that there's an evidentiary hearing and there's a specific reason that gag order is in place, not generic or everyone can't speak about it because of this. No, it has to be specific for something. And I don't think she has asked for an evidentiary hearing. I think it's just a case of now that it's happening. I'm just trying to see if there's anything I've missed here. So both sets of parties asked for a continuance of the trial. So just for transparency, this is back in March, because this was supposed to happen in March. But obviously it couldn't happen. It's too quick. So both sides said it's too quick. On this day, the parties came before the court, and through attorneys Michael Kaiser of Castellelli and Chief DPA John Huggins, on behalf of the state, to be heard on the joint motion for continuance upon a finding of good cause. The court makes the following order granting a continuance. The pre-trial hearing in the above matter scheduled for March 17, 2025 at 1 p.m. is hereby continued to August 8th, 2025 at 9 p.m. And the jury, that's Central Time, by the way, and the jury trial in the above matter set for March 19th to 21st at 9 a.m. each day is hereby continued to September 22nd to the 26th, 2025 at 9 a.m. Is that Monday to Friday then, 22nd? Oops. It is Monday to Friday. I like the fact that they think that they can just be done with it in 5 days. So there you go. Nate, hello to you. The new to the channel, but would like to say hi. Learned a lot from the current retrial on what goes on. Be listening, I thought I would say hi. Thank you very much from Australia. Good day, mate. Good day, night. How are you, sir? Nice to see you, brother. Thank you for being here. We now know your name. We know you're not a Bruce or a Sheila. We know you're Nate. So thank you, Nate. Thank you for being here, and thank you for commenting. Other people, if you're here, don't be afraid to comment. Everyone is nice. The only people that bite are Erin, Hack, and Sarah P. Everyone else is really, really nice here. So thank you, Nate. Thank you for contributing. I appreciate that. That's a Kylie Minogue song. It spins me, or is that Danny Minogue? Like spins me round, and you know that song. Yes, unfortunately, there's a nice fella, and if Keith loses his shit in the chat, just ignore him. Chat, it's fine. He does lose his shit sometimes, but he's a gentle giant. We love him here. Yeah, Karen Enriquez definitely awoke a lot of people to what's going on in the world, and I'm glad that people are starting to actually now ask questions, which is good. That's what we ask of. You don't have to agree with everything, but we should be asking questions. There's a lot of cases coming up now that we can see, especially in Massachusetts, that we might be seeing actual killers be on the loose because of poor police work, basically. But rightly so, they shouldn't be just thrown. Like, look what happened to Aaron Spencer having what do you call it? That crack pipe just placing there. That's the norm for some people. They even try and make, they're lazy investigators. They try and pin it on people, like they try to pin it on the girl. They try and pin it on people. Now again, let's just say this: it's not everybody. It's not everybody. There are a lot of good police officers out there. There are actually good prosecutors out there. But there are also shady ones out there that just want the win. They don't care about facts and stuff like that. They just want the win. And when it comes to talking about things like, I can see that there's a pedo living near me. He's just been released from prison a few months ago. Now I lost my train of thought. I don't know what I was going to say. Corruption. So police for office sometimes will try and make things easier for themselves and plant evidence and stuff like that. We see it all the time on these videos as well. And it's hard to believe that it's, but it happens, unfortunately. As I say, not all police officers are bad, so don't think that everyone's bad. There are proper investigations that happen, and there are defendants who are actually guilty sometimes, but they all deserve their day in court, innocent unless proven guilty. But this defendant is 100% not guilty. He deserves to be free. Aaron Spencer does. So please, keep shouting his name out there. They've tried to hide it. I do believe this judge is irresponsible. I do believe, in the same way I believe that Karen Reed's Judge Canone, should have recused herself, I believe this judge should also recuse herself. She's just too invested in this. And as those justices said earlier on in that video, they asked the question, is that the same judge that put the pedo out on the predator out on bail, the same judge that put this gag order in place? They were just as shocked. They're like, wow, that's not good. Talk about covering your own backs. It's not good. Anyway, that is in gist. Hopefully that aligns something. I've not watched any cases on this, so I don't know what other streamers have done on this case. Hopefully it's mine was a little bit different. I'm sure they went through more of the charges and stuff like that with you guys, but no, not yet, J-Mac. No, not yet. They didn't, no. But yeah, I try and give you a broad basis of this trial. I hope that was okay for you all and gives you some insight. And as I say, I want to play the video as well. As I said earlier on, we have 4 beautiful ladies who will be also covering this in depth, and they will be awesome at the Wrongful Pod. So please go support them. They will no doubt do a much better job than I could ever do, because they are a lot more organized than me, and 2 of them put me on for this case, Alicia and Josie. So and thank you as well to Lady Di. But yeah, I'll leave it there. Please, support. Please keep an eye out for this. Please, if you can, if you've got friends, please share this video with them. As I say, I'm not a lawyer, so I don't go in depth about stuff, but I just try and put it out there. Please like the stream. Please share it wherever you want to share it. And yeah, let's keep looking at this and see what more information. We'll do another stream when there's more information out there. We're limited at the minute, but hopefully more and more information will come out. So there you go. And what else is there? Tomorrow we got Kohlberger sentencing. We'll be live for that from I think 10, 11, that's midday Eastern. So tomorrow is KD. Hey KD, is tomorrow is that, yeah. Thank you, Nate. Appreciate you. Yes, tomorrow is Brian Kohlberger, so we'll do that tomorrow. And then I'm off Thursday for definite. Maybe back on Friday. I don't know. But I'm definitely not streaming Thursday. Or next Monday. I'm at the dentist next Monday. So Aaron Hack will not be here tomorrow. No, I know. That's fine, my darling. And with that, I love you all. I'm going to play my outro. Please, if you've not seen the intro, I'll play you on the outro. And we'll take it from there. Hang on. There you go. Right. My intro is my outro. Take care, everyone. Love you all. Ta-ra.
Like a small boat on the ocean, sending big waves into motion. Like how a single word can make a heart open. I might only have one match, but I can make an explosion. And all those things I didn't say were wrecking balls inside my brain. I will scream loud tonight. Can you hear my voice this time? This is my fight song. Take back my life song. Prove I'm alright song. My power's turned on. Starting right now. I'll be strong. I'll play my fight song. And I don't into motion, like how a single word can make a heart open. I might only have one match, but I can make an explosion. This is my fight song. Take back my life song. Prove I'm alright song. My power's turned up. So right now I'll be strong. I'll go my fight song. And I don't really care if nobody else leaves. 'Cause I've still got a lot of fight left in me. No, I've still got a lot of fight left in me.